Well, good afternoon, good evening, and good night, and welcome to what could be the mistrial of the Zachariah Anderson case. Oh god. So I'm gathering that the regulars are in the chat, so thank you very much to the what do we got? 19 people watching. Um, I slept through my alarm. I was supposed to see way more of that opening statement than I actually did. Um, So basically, I understand that Jeff is just sort of finishing off his little spiel there, and he's going to head across. But yeah, so this will be interesting. Um, while we're here, I'll say hello. Sean's in the house. Hello. Don't know about the hat, Vice's hat. Well, he likes his hat. Schroeder's back. Yeah, Schroeder is back. Hopefully, we're going to actually see him doing the trial. I'd like to see this trial, honestly. No, the trial is not looking good. But he's gone back to the case law, he's gone back to various things, so hopefully we're going to see whether or not he's going to, um, move things along. Because, I mean, look, if there's a mistrial on behalf of the state, then it's gonna wind up in the appeals court, so uh, Richard, hello. Linda, good to see you. Yes, I was still on Jeff's stream. Been watching the Oversight Committee, still another 7 House resolutions of the day, probably skipping watching if Hayden goes live, can always watch later. Ah, fair enough. Thank you for letting everyone know, Anna. I appreciate that. Just Dawn, good to see you. As a therapist, I love snow days. Can reschedule kids earlier in the day. Huh. Australian Cattle Raptor, good to see you. Rabbit, thank you for being in the chat, and I need to pin that. Um, Hang on one second. There it is there. All right, so I'm actually not that far behind. Jeff's ended the stream, so we're going to have a whole bunch of people dumping in here. Yep, already got 44 coming through, 45. Um, So yeah, as I basically just said over on Jeff's chat as well, my assistant has scheduled a very early morning client for me. So the last hour or so of this, if it continues through till 5, not going to be a hell of a lot of content in terms of commentary, but I will leave the stream running just so everyone can keep watching. So in the meantime, what we're going to do is I'm going to bring up the the defense's opening statements to see exactly what the hell has caused this to go to shit. Um, So jumps right over. Yes, it does. G'day to everyone that has just dumped in. Wow, hello to the 126th of you. I'm sure we can expect Jeff to be over here shortly. Um, but yeah, let's get stuck into it. A, so that I can work out the audio levels and make sure that everything's running properly, and B, so that I can actually get through this with enough time that we can get back to hopefully here the the decision, which I presume is going to be hopefully no mistrial, but anyway. Alright, let me know on audio levels, guys, and we'll go from there. Alright, hearing anything at the moment. Generally. Thank
All right, you may be seated. And I hope I didn't hurry you folks, but we decided to defer our legal discussion to a little later, and instead
you. No sound?
go right
Really?
to the defense opening statement. And you may
Interesting. Hang on. The clarity of the video, I can see each individual hair from his goatee. Thank you. There was a
Ow!
St. Louis shooting this morning? No, I haven't seen it.
Nah, there's always shootings in St. Louis. It's St. Louis.
Alright, hang on.
Don't have as loud of a voice as the state, so have to use the mic. The essence of this case is
It's a little
actually
quiet.
quite simple.
Alright, hang on.
The state just walked
Ooh.
you through for quite some time about the evidence and how
Let me know
it
if that's
thinks
still
it's going
too
to come
quiet.
through during this trial. But at the end of the day, law enforcement nor the state have no idea what happened to Mr. Gutierrez's body. They don't know when exactly anything happened in Mr. Gutierrez's apartment. They have no idea where any alleged remains of Mr. Gutierrez's body is. They have none of that. There are no witnesses that saw my client, Mr. Zachariah Anderson, at 3709 15th Avenue in Kenosha on May 17th, 2020. They have absolutely no witnesses that say, hey, we saw Mr. Anderson and he had bloody clothes or he was acting suspicious. They have none of that because none of that evidence exists. No body, no human remains, no indication of cleaning up a crime scene despite what they state occurred in that van. I'll talk to you a little about that later. They don't have any of that. Yet they decided to build a script, and the evidence will show you this. They decided to build a script and tell a story and make Mr. Anderson the main character, despite the fact that
Just quickly, someone said, what happens if the state gets a mistrial? My understanding is that they'd have to go to the appeal court,
Yep.
isn't it?
Well, it
Yep.
goes over again. It just do over.
they didn't have any of this evidence. No body, no human remains, no witnesses, nothing. If you're looking in the wrong places and at the wrong people, you are not going to find the information you're looking for. The state just talked to you at length about some of the evidence that it believes is going to come in, and that evidence is going to show you that Mr. Anderson committed the crimes as charged. And the state and myself, he explained to you kind of what opening statements are. Not going to do that. You're all capable people of understanding why we're speaking to you right now. But I'm speaking because I see the evidence a little bit differently. And when I'm walking you through the evidence that will come in today, it's not based on speculation. It's not based on some theories that are in my head where there's no evidence to back that up. I'm going to walk you through the actual evidence that will come through during this trial. But let's start with what the state kind of walked you through, that this really all stems because Mr. Anderson is a crazy, jealous, obsessive ex. The evidence during this trial will debunk that theory. And in addition to that issue, motive is not an element of the crime. In order to be threatened by a serious relationship has to exist. The state talked about how things were getting heavy between Mr. Gutierrez and Miss Beecham, that they were meeting each other's kids, that there was talk about that. What the state didn't inform you was that Mr. Gutierrez was actively dating and seeing several other women. He was not in any means exclusive with Miss Beecham. He had in fact told some of his closest friends that he was intending on breaking up with Miss Beecham. Miss Beecham had never met a single one of Mr. Gutierrez's friends. And this concept of that the state talked about how, she had never talked to her child about Mr. Gutierrez, or that information must have come from Mr. Anderson. That's not accurate. And the text messages that will come in will establish that Miss Beecham had discussed Mr. Gutierrez with her daughter. There were text messages that she sent to Mr. Gutierrez that says, Liv wants to meet your kids before she meets you. Well, obviously, she must have had a conversation with her daughter about who Mr. Gutierrez was, but still doesn't change the underlying factor that this was not a serious relationship. Additionally, from February of 2020 through May of 2020, there was consistent communication between Mr. Anderson and Miss Beecham. And that communication wasn't, oh, I want you so bad, come back with me. It was kind of a mutual agreement that their relationship was toxic. They were never getting back together, that she had guys she was seeing, and Mr. Anderson had his own girlfriend. The timeline. The state said that the timeline shows Mr. Anderson must have been involved, but the state's ignoring critical evidence as to that timeline. The state admitted May 17th, 2020, Mr. Anderson had his kids, his 3 children. They were at his home in Mequon, Wisconsin. That later in that afternoon, around 5 to 6, Miss Beecham picks them up. Mr. Anderson then, they don't have any evidence that Mr. Anderson left his home. They claim that this is the time where he traveled down to Kenosha, but you'll hear from law enforcement officers that they got surveillance video from multiple places, not only in the Mequon, Ozaukee County area that Mr. Anderson would have had to pass to get to Mr. Gutierrez's apartment, but they also got surveillance from gas stations, schools, the transit authority, from the buses, from neighbors' ring cameras from the area in Kenosha that Mr. Anderson would have had to have passed if he was driving. And you'll hear from law enforcement that they don't observe Mr. Anderson's vehicle. So the state has absolutely, there will be no evidence during this trial that will be presented to you that shows that on May 17th, 2020, when Sadie Beecham is at Mr. Anderson's home, she sees him there. He then texts someone at 11:19 p.m., and you'll hear from law enforcement officers that his phone pings at his home at 11:19 p.m. Nothing shows he ever left home that night. People falling asleep around 7 to 8 p.m. as adults who have children and have been with them all day, that's not unreasonable. So the next morning, he wakes up, he goes to Walmart. You'll hear evidence that Mr. Anderson's a contractor. He was going to a home up in Cedar Grove area that he was working on. He was doing lath removal and other serious removal jobs. It was basically a complete reconstruction of the property. And so if he went to Walmart and parked far away, you'll hear evidence that he likely had tools in his van. And in addition to that, he then goes to his job site for 3 hours. And the state's saying that after that, they don't know where he goes. No idea. The evidence will establish that after he was at the house in Cedar Grove for 3 hours, he went to Menominee Falls to pick up his taxes. That's a nice fact that the state didn't talk about that will come in. And what's interesting about the fact that Mr. Anderson had gone and picked up his taxes in Menominee Falls right after working at his job site in the morning is that that evidence wasn't readily given to the defense. That you'll hear that this evidence, this receipt that stated 5/18/2020 from the tax accountant services was a piece of paper that was located in Mr. Anderson's van. And that law enforcement, when they executed the search on Mr. Anderson's property, they took all the papers and put them in a pile and labeled them miscellaneous papers. And they took one picture of all of those papers and put that into discovery, and that picture's blurry. You'll see that picture. It
She
wasn't
just said
until the defense
miscellaneous.
asked to see that documentation that we saw this receipt.
She's on a roll. I wasn't
that
going to interrupt her.
proved that Mr. Anderson wasn't for hours getting rid of a body, but was going to pick up his taxes in Menominee Falls. And you'll hear from the accountants that he was there. You'll also hear from them that they had video surveillance, that law enforcement, had they gone and talked to these people, would have been able to get that surveillance video to see what Mr. Anderson was wearing, the fact that he didn't have any blood on his clothes. And then after he picks up his taxes, he goes back home and spends the night with his girlfriend, Christine Remsburg. The next morning, they wake up. It's a normal day. But it's not normal for Mr. Anderson because two random people show up on his property demanding that they speak with a person named Zachariah Anderson. And Mr. Anderson knows that he doesn't know these people. They don't know what he looks like. So he says, hey, I'm his brother. He's not here right now. What do you want? And they say, as the state noted, we're looking for our missing friend from Kenosha. And these people are snooping around his property, acting suspicious. And so what does Mr. Anderson do? He calls 911 himself and says, hey, there's these two random people that are on my property demanding to speak with me. I told them that I'm my brother because I'm a little concerned about why they're here, and they're demanding questions about their missing friend from Kenosha. The man who the state's alleging had something to do with the disappearance of Mr. Gutierrez is calling 911 and saying they're saying that I had something to do with this missing guy from Kenosha. Law enforcement responds to the home, but it's not to respond to Mr. Anderson's concerns. They're there to arrest Mr. Anderson and to execute a search warrant on his property. He's taken into custody. They take pictures of what he's wearing: white t-shirt, blue jeans. They send some of those, they say, oh, there looks to appear to be a stain on this shirt. Let's swab it and send it to the crime lab, not blood. No DNA of Mr. Gutierrez. Oh, the jeans, looks like there's another red dot.
Hey, Mandy.
Let's swab it and
sorry,
send
Michelle.
it to the crime lab. No
Apologies.
blood, no DNA linking back to Rosalio Gutierrez. They took pictures, you'll see these, of Mr. Anderson's hands, feet, arms, not a single scratch, not a single bruise, nothing. So the state's assertion that there's going to be evidence that Mr. Anderson had time to get rid of every single possible piece of evidence, the body, all remains, everything that he used to clean up. The state talked about some items bought at Walmart. They were 13-gallon trash bags and 2 things of Clorox wipes. Don't think that's enough to meticulously clean up a crime scene, nor is there any evidence that
when he said they had
additionally
when he bought
as
bleach,
you'll hear, this was during
he
the
bought the
height
Clorox wipes, 2 packages of Clorox wipes, not like bottles and bottles of bleach.
Right. Okay, hang on. I'm just gonna just a little bit low for me. I'm not sure if it's low for everyone else. I'm just gonna boost you solely for me. So far I haven't heard anything specifically that would tie him to this. I mean, if the police officers legitimately took a photo of some miscellaneous papers, and one of which proves that he was in a particular place at a particular time, how the hell did they even bother to arrest him?
Well, see, and you know, if you recall from the previous mistrial, the opening, he said that he bought bleach and that they found like what is it, charred bleach bottles in the fire. He didn't mention finding charred bleach bottles in the fire this time. He just said he bought bleach, and she clarifies apparently that it was just the wipes, and then she goes into why it was very normal for people to buy 2 packages of Clorox antiseptic wipes.
Exactly, as Leafy Fifu Fee says here. I hope I got that right. It's not unreasonable for someone to want to clean their house. I mean, bleach wipes get used very regularly to clean the toilet around here. So,
well, she has even a better explanation for it.
Oh, really? Okay, let's continue then.
COVID.
It was the height of COVID, and everybody was buying them.
Still almost about to be the lockdown, or actually was in the middle of the lockdown.
Yes.
So searching to see what stores are open before you go to a job site is not bizarre. You'll
Yeah, they
also
said he
hear that
Googled
during
what time stores
COVID,
open, which
items
stores
such as
open first.
Clorox wipes and gloves were
Oh,
extremely
dear
hard to
God,
come
shock
by,
horror. Let me
and you
clutch
would
my
pick them
pearls.
up when you got
It's not
the
like I ever
opportunity.
check whether or not a store's
Yeah.
open before I go there.
So the timeline that the state told you, there's evidence that supplements that shows Mr. Anderson could not have had the opportunity to commit the charged offense. The other piece of evidence that the state talked about was Marquand Washington,
Oh,
and that Mr. Anderson allegedly
you might want to
admitted
push
to
pause here
him
for just a
that
second.
he
so
did this
we can-
and that he's
so we can
What's up?
update you. Marquand Washington, was that his name?
Mhm.
He was he was his cellmate in prison, who said that
Oh, so, okay, very
that
legitimate.
he confessed. He confessed to stabbing him and rolling up the body in a rug and hiding it in trash bags and things. So it's the old prison house confession thing.
And I
That's
was
their
gonna say,
star
exactly
witness.
do we know how long Mr. Marquand is serving and what he would expect to
yep.
receive off his?
She goes into that right next. Just kind of want to give you that was the argument the prosecution made. His cellmate, he was singing like a bird to his prison cellie.
Any opportunity to get a reduced sentence, I swear to God.
See, and that's exactly what I said. And Aussie didn't see me say it. That's just the first thing I said. The first thing you do is you go, "Oh, hey, DeQuan or whatever your name is, you're in prison for committing crimes, right? Oh yeah. So you want your sentence reduced, don't you?
Mhm.
Yeah. So you'd lie to get your sentence reduced, wouldn't you? And then you walk away.
Yeah.
So,
So for
right,
my
there you go.
regulars, we know when we went through this with Cheeseburger, which is going to confuse a hell of a lot of people who are currently watching. When we were watching the Triple X Tentacion trial, one of the four that were accused of the murder flipped on the other three, and he'd already pled to second-degree murder. And basically, the first thing that the defense counsel got up and did was, well, are you going to be getting a reduced sentence in relation to this? And the answer was no, because he was already getting a mandatory life sentence for it, despite having pled to second degree murder. Yes, I'm aware, Brian, the trial's still going. So, shock horror. Apparently the judge just took a day off without telling anybody. Yeah, basically. But in that instance, he himself was a believable witness, which is really interesting because you don't always see that in terms of the people that have already been convicted. Because, as I said, he was still facing a life sentence, but he himself hadn't been sentenced yet, simply because the other three were on trial still. And I think the judge wanted to do the sentencing all at once. But
and see, this is
there
a
are
good reason. Oh, good. Sorry. There we go.
No. I was just going to say, actually, I've lost my train of thought. What were you going to say?
Oh, I'm sorry.
Oh, good.
This is why, like, when you watch the crime shows, true crime shows, or these jail shows where they put people in jail and whatnot, you never ask another inmate, so what are you in here for? That's only happens in the movies. That does not happen. That will get you an ass beating of epic proportions. If you actually go, hey, what are you in here for? Yeah. Because that immediately signals to the hearer that you're trying to get all up in their case so you can flip on them. So you can rat them out. You can snitch them. You go, oh, you would never ask another inmate that ever.
Oh, hell no.
Yeah,
It's the easiest way to get your ass beat. That and being in there for certain charges, it just...
Yeah.
Yeah.
Yeah, but these all, so what are you in here for? That's mind your own effing business, or you'll get shanked, because it's none of your damn business what I'm in here for, because they know you're going to snitch. You're going to make up shit. Yeah. You're going to snitch.
Okay. All right. So.
Stabbed Mr. Gutierrez, took his body, put it in some trash bags, and took the trash out and got rid of him forever. The state talked to you a little bit about Marquand Washington. Marquand Washington is currently facing a minimum of 10 years to life and it's a federal case. And you'll hear during this trial that in federal cases, when there are mandatory minimums, the only way to deviate from that mandatory minimum, so the only way to get less than 10 years is if you cooperate. If you provide information
If you
and
snitch.
then get on the stand and testify to that and cooperate, that the government, who's the prosecutor in a federal case, can file a document to say, Judge, we're asking for lesser than that 10-year mandatory minimum. And you'll see that in Mr. Washington's plea paperwork, the government nicely outlines that in order for you to get less time, this is what you're going to have to do. Now, the state didn't mention this to you, but Mr. Washington is someone who will literally do anything to get out of his situation. That they had evidence, that the federal government had evidence that he intimidated the witnesses and victims in his own case in an attempt to get out of his situation. And when that didn't work, he was left with one option: cooperation. And in February of 2022, the federal government was told that he had information that he wanted to share. And they wrote a letter to him and they said, Mr. Washington, we've heard that you want to share some information about some crimes that you have not.
Hang on. Damn you, Obama. That was funny. Actually, I did want to address this one here too, just while we're on topic. Except for the hundreds of prisons where inmates immediately ask you for your papers to make sure you're not a twisted fucker. As I said, that's the certain crimes that will also get your ass beat.
Yeah, and then that's interesting. They'll ask to see your paper. They'll ask for the paperwork. They're not going to ask you, just say, hey, so what are you in here for? They're going to be, hey, let me see your papers. And if you don't give them the papers, they can have someone on outside just run a background check on you and find out what you're in there for. But they're not just going to ask you, and you're not just going to go, okay, I'll tell you.
No, exactly. And I've got the ticker down the bottom, but for anyone that is new and doesn't know, when super chats come in, I will bring them up so that they come across when they're appropriate, but we do discuss them and I will run back through them. So, all right.
Knowledge about in the Milwaukee surrounding area, please let us know what that is. He did not mention Mr. Anderson in February of 2022, and that's critical because the state said that Mr. Anderson trusts Marquand Washington, but Marquand Washington only was housed with Mr. Anderson for approximately 3 weeks. It was a very short housing situation. And those 3 weeks was from December of February of 2022. Or no, sorry, I apologize. It was December of 2021 to January 31st of 2022. So in February of 22, he would have had this information.
I need to clean my office.
But he didn't share it then. No, he only shared it about 3 in a case that's been going on since May of 2020, when he's allegedly had this information for almost 2 years.
Yeah.
But what's even more critical is Marquand Washington, as the state says he will testify, and I'm saying as the state will say he will testify because the defense did not have the opportunity to meet with Mr. Washington. Mr. Gravely, the district attorney, and Vincent Carrera, a detective, they met with Marquand Washington, and they questioned him for an hour and 30 minutes approximately. They did not record the interview. Instead, they gave the
Zachariah
defense
Anderson,
a 2.5-page
allegedly
summary
killed his
of what he would say.
ex's new partner or boyfriend.
But what I do know from that 2.5-page summary is that he claims that Mr. Anderson said he stabbed the guy.
Mm-hmm.
The officer, the state talked about how you'll hear from officers about the blood stain pattern analysis completed in this case. That officer will tell you that he believed that the stain patterns that were seen in Mr. Gutierrez's apartment were consistent with blunt force trauma. That was his opinion just in February of last year, Officer Van Wee, and in his reports from closer to May 2020, he wrote that he believed it was blunt force trauma, so a heavy object or an object hitting someone, And also Detective Carrera wrote in his reports that it was blunt force trauma. There was never a single mention in Van Wee's reports or Detective Carrera's reports that the stain pattern analysis were consistent with sharp force injuries. There's a difference between blunt force injuries and sharp force injuries. Sharp force injuries is a knife. No mention of that. In fact, you'll hear that Mr. Gutierrez was an avid baseball fan, loved baseball. Not only did he love baseball, but he loved to play baseball with his kids. And he was a coach.
Wait, okay. So we've got blunt force trauma supposedly spraying out, what, liters and liters of blood around the place, and they still haven't found a body.
Yeah.
Have they checked
And
for brain
meanwhile,
matter?
Jailhouse Snitch is saying he was stabbed.
Right.
And now this is where she starts to get into the theory of other people doing things.
Okay, so we're coming close to...
Which
All right,
led to
gotcha.
this issue.
So some pocket knives have window breaker things on them. Works great for beating someone. Lovely.
Yeah. Not this kind of beating, though.
A hatchet is still going to be sharp force trauma provided you hit them with the bladed edge.
Yeah, it depends which end you use. Which side you use.
He faked his own death to get away. Love that. Okay. All right.
For minor leagues. And so he had baseballs in his apartment and in his truck. He had gloves in his apartment and in his truck. You know what wasn't recovered in the crime scene? Or in a truck? Not a single baseball bat. Not a single one. But the state told you that they had a shard of, the state said it themselves, what could have come off of a baseball bat with blood on it. So the evidence will contradict itself. It can't be the stabbing and it can't be the baseball bat. The next item that the state talked about was the DNA in the van, and the state claims that there will be a witness that will get up here and tell you that that was blood in that van.
Yeah, this is.
I'm not sure where that's coming from.
Mm-hmm.
Because Lisa Treffinger, who's an analyst at the state crime lab, was the individual in charge of processing the van and that particular dot. And it was so small, like freckle size. She's the individual responsible. And you'll hear from her and other state crime lab analysts that they processed that van extremely thoroughly. You'll see pictures of the van too. Not a van that's been cleaned. There's dirt everywhere, dust on the dashboard, no indication that it's been cleaned, no blood in the front driver's seat. In fact, no blood anywhere. They saw red dots, tested it for blood. They did a test that's specific to determine if a item that purports to look like blood is blood, negative. They did luminol testing. I don't know if any of you are aware of that, but what they do is they spray this substance and it will...
Hang on. They tested it with luminol?
Yep.
So rust could have triggered it off, basically.
Could have.
Which is theoretically a red substance that you may find inside a vehicle.
Yeah.
And would show positive.
It could have triggered. It could have triggered a positive.
Interesting.
Will basically light up if there's the presence of blood. Didn't light up. They said
so it's negative.
Was one flicker of light, so they tested that area. Negative for blood. This dot that the state claims someone's going to tell you was blood, in an email from Lisa Treffinger, the analyst that will testify, you'll hear her tell you that the state asked her, an email from the state, I just wanted to confirm that the sample that was sourced to Rosalio from the van was blood, right? This was analyst Treffinger's response, and she'll testify to this. We could not confirm it was blood. Her own words, not mine.
Little different than what the prosecution says.
No. How do you explain that? The state claims that the explanation of how Mr. Gutierrez's blood got in the van was because Mr. Anderson must have killed him. But the evidence will tell you that there's a far more logical explanation for how that occurred. The state talked to you about the evidence that might come in about an incident that happened on April 24th, 2020, where Mr. Anderson had gone into Mr. Gutierrez's vehicle, had taken something out. This was talked about between Ms. Beecham and Mr. Gutierrez at length. Ms. Beecham told Mr. Gutierrez on April 25th about what had happened, how Mr. Anderson had gone in his car. And they talked about how maybe something should be done about that. There was conversations between them about how maybe Mr. Anderson should get a taste of his own medicine. Later that night at 11:10 p.m. on April 25th, 2020, Ms. Beecham received a text from Mr. Gutierrez that said, "What's his fucking address?" Sadie responded, "Well, I guess if he has your info, you should have his." And then Mr. Gutierrez sends her a text with Mr. Anderson's address. This is on the 25th. And then on the 26th, he sends her a text that says, "For the record, only if you say it's okay." He also sent, and then Ms. Beecham sends him a text, "He's gonna find out." This all happens on the 26th of April. Mr. Gutierrez is apprised of the fact that Mr. Anderson went into his vehicle. Sadie and Mr. Gutierrez talk about how something should be done similar to Mr. Anderson. And then on April 26th, 2020, Mr. Gutierrez's Cellbrite location data puts him at 6813 Highland Road, Mequon, Wisconsin. He's there. Mr. Gutierrez, after talking about how something similar should be done to Mr. Anderson, that something similar being going into a vehicle, is at Mr. Anderson's house. His location puts him there. And then right after he's there, he has a video FaceTime with Miss Beecham for 2.5 hours. And that conversation occurs at 3:11 a.m. in the morning.
Oof. Go to sleep.
We can't talk.
Not for 2.5 hours.
In addition to the fact that there's more reasonable explanations, as you'll see through the evidence, that is ignored by the prosecution. The fact that the timeline illustrates Mr. Anderson could not have done this. The fact that no one puts him there on May 17th, 2020. The fact that there is no blood in the van, there's no body, there are no remains, there's no murder weapon. They still are going with the fact that Mr. Anderson committed this crime. That's because, remember, that's who they chose as their main character.
This is where she starts to get in potential trouble.
They ignored, and by they I mean law enforcement ignored, legitimate leads and follow-ups, suspicious people. And they ignored that because on May 19th, 2020, when law enforcement met with Sadie outside of Mr. Gutierrez's apartment, she said, "My ex had something to do with it." And they said, "Great, let's run with it. We're going to try to build a case around him, even if we don't have a body. We have no explanation of what happened to him. We have no explanation of where Mr. Anderson would have put a body. We're going to run with him." So what did they ignore? They ignored Miss Beecham. Miss Beecham, as the state noted, went to Mr. Gutierrez's residence at around 11 a.m. on Monday, May 19th, 2020. She had only been dating this guy for a couple months. This guy was dating other people. They only saw each other every other weekend, some weekends that, it wasn't a hot and heavy relationship like the state wants it to purport. The evidence isn't going to show that. So she's only been dating this guy for a couple months, a guy she met off of Facebook dating, and decides, you know what, I haven't heard from him. I'm going to go to his house in the middle of the day when he would be working to see what's up. Sure, there could be innocent explanations to that, but you'll also hear evidence that Miss Beecham had constantly been texting with her best friend, Rebecca Jekyll, about how she thinks Zach's tracking her, but can't prove anything. She says that. She says that to Rebecca Jekyll, and she's complaining about it. And
that's a reference to the potential mobile phone being left in the car, isn't it? That he was using a burner to track her.
Yeah.
All on 5/14/2020. She's complaining about it. Text messages between her and her best friend, Rebecca Jekyll. And on May 14th, 2020, Rebecca Jekyll randomly texts Sadie Beecham and says, in this discussion string where they're discussing how she, is so irritated with Mr. Anderson, Miss Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And what's 1 week later? When she's at Mr. Gutierrez's apartment. So if we could have the objection heard outside.
See, did you catch anything there?
Yeah, what?
Did you catch anything there that sounded like she said that Sadie was arranged the killing?
Look, that text message, the whole, all I've been told is that it's been organized, call me in a week sort of thing. Look, I can see how that may be interpreted as she's organized a hit on his life. I don't see enough here for the mistrial so far, and presumably the objection being heard now, we've heard everything that's going to be said.
Can we go back and hear that again?
Yep.
I just want to be really clear of the wording.
That's what, 30 seconds.
Rebecca Jekyll randomly texts Sadie Beecham and says, in this discussion string where they're discussing how she, is so irritated with Mr. Anderson, Miss Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week.
I'm just putting it out there. That to me sounds like it could easily be one of those like fake kidnapping experience things that you can pay for. Like I know that there's some idiots out there that actually pay for them to have themselves huddled into a van and like disappear for a week and shit like that as an experience.
Kinky corner starting to pay off for you, isn't it? I never would have thought about that in a million years, but you could be right.
Well, it's the exact wording of it. I mean, yes, it could easily be organizing for someone to be injured, for someone to be, have their get kneecapped or something else like that. There are plenty of other innocent explanations for what that could be. Now, as for what she's doing here and pointing the finger, I do find it interesting that she's not allowed to be doing that, because that's not necessarily how things would work in my mind necessarily in criminal court here. I do think there's definitely insinuation there. I don't know that she's explicitly saying. At this point, I think it could be anybody, but she's definitely proffering that the text messages gift out. I'm really hoping that Schroeder comes.
Me too. Me too. But I mean, listen to these arguments. I mean, she makes some fiery arguments.
Okay. Well, I mean, we've got, what, 9 minutes before the court's supposed to be
Yep.
back and we'll get an answer. So hopefully we'll
That's
get burned through this.
It's about the right amount of time.
All right.
What's 1 week later? When she's at Mr. Gutierrez's apartment. So if we could have the objection
Screw
you, Val.
outside the presence of the
Go
jury.
ahead, Ms. Gravely.
Yeah, what?
What did you say?
I do want to do it outside the presence of the jury. I apologize. This thread is something that we've litigated prior.
Generally, well, folks,
Apologize.
If I may.
quiet, please.
Probably bring it up in a separate browser just so I can be
Um,
give me a second, guys.
I'm going to ask you to step just into the library. If somebody needs to go upstairs, you're welcome to do so, but come right back down. But go into the library, and I don't think this will take long, and
I don't think this will
make
take
yourselves
long.
comfortable there, please. Don't
Okay.
talk about
Yeah,
the
no,
case, please.
it's still, they're still at recess. Wow, the chat in Law and Crime is not being nice to Schroeder, that's for sure. Yeah, that's sort of how I. Oh, hey Zenith. Hi. Point was made that was law enforcement failed to look at any other potential suspects. That is certainly one way of looking at exactly what she said there. I'm very much hoping that the court doesn't take it the other way.
Gravely, I hadn't pressed the button, that's why.
My objection is that the defense line of argument that's just been stated regarding Sadie Beecham is a violation of State v. Denny. To be able to name a party and indicate that there are factual circumstances that are consistent with them being guilty of procuring this homicide in the alternative is exactly what Denny was designed to prevent. The court is aware that Denny asks that the defense file a written motion giving all parties notice so that the parties do not, in mid-trial, have alternative actual named parties be described, as well as factual circumstances which are designed to cause the jury to suspect that person is an alternative individual. This is exactly what Denny was designed to prevent. And now the name Sadie Beecham has been associated with this jury with being involved in planning a homicide of this individual, and that's in direct violation. There is no doubt that the defense is on notice as to what Denny is or its expectations. We litigated a Denny motion just last week where they laid out a direct foundation. These are, again, the quoting to the jury are text messages. These are not new pieces of information. And frankly, as I indicated in the prior Denny motion, the court has an obligation as a steward of this information to be sure that all parties are dealt with fairly here. We are required to be able to be provided notice if individuals are out there in that situation and be able to defend those individuals. And the court is required to rule on this beforehand. So I believe this to be an improper argument. I don't think it can be cured at this point. And so I ask the court to consider what our remedies are. But I believe that this is a clear Denny violation and that this is a mistrial.
Okay, two things. So the Denny rule requires motive, opportunity, and some evidence which is not remote in time, place, or circumstances. So I would argue that if we're going on a tenuous link, the text message itself should be able to support that there is a potential for motive there. Or, sorry, not for motive, for arranging opportunity. So even if he's going to make a Denny argument, it's altogether possible that it may be able to be pushed through. I'm actually starting to think that. Sorry.
Go ahead. Sorry, you're starting to think.
Oh
What?
no, I was just going to say I'm starting to think that maybe Schroeder may rely on that to get it through without it being a mistrial.
Listen, you have to make the motion first, though, and she didn't make the motion for this specific.
So
witness.
it's a formality, technicality. Okay, gotcha. That's a pain in the ass. Okay.
If I may be heard, Judge. Thank you. In my opening statement, before I started going into this sequence, I talked about how law enforcement did not follow up or look into anything as far as possible other suspects or leads. I'm not offering this. And first of all, I'm just talking about the evidence that's going to come in, right? At this point, this is what the opening statement's for.
Oh, good God.
This is
Hang on. She just did the white girl. Right? Sorry.
a message string between Miss Beecham and another witness. This will come in. And it's not to offer it, Judge. It's not to offer it to say it was her. It's to offer it to show that law enforcement did not investigate her, did not investigate anyone else. That's not a Denny motion. I'm not pointing the finger. I'm not saying Miss Beecham did it. I'm saying they could have followed up on this. They should have followed up on this, and they didn't. It's very different.
First of all, you're telling me it's not coming in. And if it's not coming in,
Why is it being raised?
then you're not supposed to talk about it.
No,
Yeah.
I said it is coming in, that this will come in through witnesses.
Say it wasn't going to come in.
No, sorry if
I heard you wrong.
okay.
Did you want to respond, Mr. Waverly?
Yeah, you can talk about whatever purpose you want. The argument made to the jury is other people should have been looked at. I mean, you couldn't be more clear in your argument. The argument was other people did this crime. My client did not. Other people did.
Of
Here's
course,
example one.
she's a defense
Now
lawyer.
laid
That's
out
her argument.
Specific electronic evidence that she wants the jury to be presented. So not only is she making an accusation, the substance of this accusation is that Sadie Beecham and a friend of hers have conspired to find a third party who will kill this person. That's the allegation that's been just made.
Ooh.
And she's indicating
Sorry, they're right. The court feed is back.
All right.
No audio though. All right.
that's what the text.
I'll play
would
it through
lead a
there. We'll hear it
reasonable
as soon as
person
it
to
comes through
believe.
anyway.
There's been no notice of that specific allegation. The jury has now heard it. It's been shared with the jury. There's a whole body of case law in Wisconsin that does not allow a private citizen to be accused. And for a person to say, well, that's not for the purpose of accusing another human being of murder. That's what she's done. That's the argument that's been made. It doesn't matter
There's
if
so
that
many
is
people
not
I'd make that application
if
for.
that's not the sole purpose you have. Your objective here is to tell the jury, hey, there's reasonable doubt. Sadie Beecham did this. Look at this electronic message. That's why you argue that. There's no other reasonable argument as to why this has been shared with the jury.
I disagree with that. I think that the fact that she brought it up that the cops didn't look into her properly is a completely different way of making that argument.
Yeah. See, I think that's where it is for me too. She doesn't say she specifically did this. She said there's these kind of things. And they didn't look at it. They didn't look at her. And then she was going to say they didn't look at this guy. They didn't look at that dude. They didn't look at this.
Mm-hmm. Yeah, I completely believe that that's what her argument was going to be.
And why weren't we given notice of this? Why wasn't when a Denny motion was filed with all the details? And I complimented the defense just a week ago when they provided their factual circumstances so the court could litigate that with the state, because I believe that's the entire proper procedure. I'm on record as having complimented them for supplementing and providing a factual basis for the court to make a fair ruling. And we are in complete absence of that in this situation. This can't be remedied. Sadie Beecham has been accused of murder when Denny exists as litigation in this state.
If I may respond.
Even he's going,
Thank
no.
you, Judge. I have not accused anyone of anything. I think it's been very clear that the defense is saying that none of this evidence exists, and law enforcement, instead of doing their jobs to investigate, just went with a single individual, that they had tunnel vision. An extremely proper defense, and this does not fall under Denny, is to say what the law enforcement didn't do. I'm not here to purport that this is what happened, nor have I said that. During trial, it'll be, this message was sent. Hey, detective, were you aware of this? Did you look into it? Do you think it's a little bizarre? Yeah. And leave it at that. Nowhere have I just said right now that I intend on pinning this all on Miss Beecham, nor have I think that has been the theme of my opening statement.
But if you don't have greater information than that, and Why is it relevant? I mean, what difference would it make whether the police followed through on it or not, unless there's reason to believe that that was the person who
Oh,
was
Miss Dingy.
responsible for the disappearance of the decedent. It's irrelevant. And I mean, I'm hoping they didn't investigate me too, or Mr. Gravely, or Ms. Krizarek. They'd have to have a reason to do that. And if there isn't abundant reason to suspect that Ms. Beecham was involved, then I think Mr. Gravely is quite right. This is just a camouflaged Denny effort.
The defense would respectfully disagree with that, Your Honor. By sustaining the state's objection, the court would ultimately be holding that the defense cannot go into how law enforcement didn't do their job, which in a case where there's no body, no evidence of human
Why
remains.
didn't you file a motion?
It's not a Denny motion. I'm not offering this to point the finger at someone to say this person did the crime.
We have an alternative actor theory.
It's not an alternative actor theory. And if I could maybe give a preview to what was going to come next, is the 20 other things that law enforcement didn't follow up on. It's more targeted, if I may finish, it's more targeted to what law enforcement did or did not do, opposed to what some third party did or did not do. That is what this is going towards. And the defense would maintain that that is extremely relevant. It does not fall under the curtails of Denny, and that we are permitted to go into that in opening argument and during the pendency of this trial.
Okay, I want to be heard on the precise thing that was said by the defense, because this is a disingenuous argument to say, my argument is just a police officer. Here's the text message. Isn't this weird? That's what she just told you. Here's what she represented to the jury. She said that she read the text message and said that this mysterious third party will take care of this, but you won't know the details and we'll know in a week, right? And then she said, she commented.
I would argue that that's enough that the police should have made some sort of investigation, though. If it's a communications out of the ordinary, it's creepy as hell, irrespective of whether or not it's just someone getting thrown into the back of a van for a kidnapping experience or whatever. I would argue that the police should have still done their due diligence. I don't think she's done anything wrong here.
To the jury, and a week is when Sadie Beecham goes and discovers this bloody scene. So she ties it in. She says, guess what, jury? At the end of the week, it's Sadie Beecham who, in response to this message, has now made this discovery. This is implicating Sadie Beecham directly in a homicide. That's the only reason you make that argument. She didn't remark, and I didn't object when she first began to speak. What she told the jury was that this is bolstered by Sadie Beecham being the person who discovers this scene a week later, which is in accordance with the detail with the text. This should not be investigated by the state on the fly. This is just not Denny does not allow a scenario where a fellow human being can be accused of a homicide and the state is expected to figure out on the fly what this information leads to. The jury has every
You do your
reasonable
fucking job in the
expectation
first place,
now
then.
that Sadie Beecham could be the killer based on what's been said. That should never, ever be said in a courtroom until Denny is litigated, ever. I mean, this is a line that it's not even a close line that's being crossed here. And we remedied for this jury.
What I was going to say before the objection came was that even just, okay, so it's still, again, not being offered to point the finger at her. And I'm not sure.
Frankly, your Denny motion that I denied with respect to Mr. Campbell, I might have granted the one on this one because there is not more body to it. So I think Mr. Gravely correctly is concerned that this is just, as I said, a camouflaged Denny motion or effort.
I disagree. The defense disagrees. This is law enforcement. So we can't go into how law enforcement investigated this crime then. Would ultimately be the court's holding, because there's
That's not the court's holding.
So why didn't you investigate the person who just happened to find all of this? So is that pointing the finger?
That's not the issue before me. This isn't midway through the trial that you didn't ask some probing questions of the detective if he testifies. And ask, well, did you look at this? Did you look at that? To try to show a sloppy investigation, if you think it was. This is in your opening statement and planting a seed and it's all right to plant seeds. That's why we have opening statements. But this particular one has a special body of law handed down to us from the Supreme Court of the United States. And as I say, you correctly brought the Denny motion on Mr. Campbell's issue, but I think this is, it's in the same category.
If I can further be heard.
Yeah.
So what is the difference then between saying law enforcement, because I do anticipate talking to Carrera and other detectives about.
There is before.
Here we go.
Anything further to be stated?
There will be further argument from the defense. Attorney O'Bear will be handling that.
Okay, you have the floor.
Make sure I'm turned on.
Okay, looks like we didn't get a mistrial.
We did some more research over the lunch hour, and I wanted to point a couple of things out. First of
Mr.
all,
arguing about the motion.
in the context of the particulars of this case, it's very obvious that the defense is that Mr. Anderson did not commit the offense. So this is not one of those defenses where we're attacking an intent element or the manner in which something was performed. Our theory, of course, as the court is well aware, is that he didn't commit this alleged crime. The comments that were being made by Attorney Mueller during her opening statement were part of a larger argument and in proximity to the point that she had just previously made, which is that that the investigation focused solely on Mr. Anderson. And in fact, the words that she made in terms of what our whole theme and theory of this case is that there was a script that was written. Mr. Anderson was the central player, the main starring role in this script. Now, as in any case where there is an investigation, and if it's the defense's intent to argue that the defendant did not commit this offense, it's part of virtually every case where reasonable doubt is what we're addressing. Am I not being loud enough? Reasonable doubt. I'll try to talk more directly into it. The angle's funny here. So it's really a matter of looking at what the entire investigation entailed. Everything that Attorney Mueller was discussing in her opening statement was based on information that had been provided by the state. Now, there are a number of different scenarios in which Denny can be applicable. And just taking a step back as to what the purpose of the Denny rule is so that on a very basic level, the defense can't create some sort of theory that the man on the moon or an alien
in
from
Ohio.
outer space came and did it without any support for that. But on another level, if, let's say, in the course of a defense investigation, evidence is uncovered that could theoretically point to a third-party perpetrator, the reason for the notice and procedural rules behind that scenario is that the state then should be given the opportunity to investigate with their resources as to the viability of that potential third-party candidate. This is different from that in the sense that we're talking about evidence that was turned over from the prosecution to the defense. And our point here is merely that, and this is one of several different points, things that were not followed up on. So what I was looking at over the lunch hour is, interestingly, some aspects of the Kiles versus Whitley case, which the court's very familiar with from 1995. Now, that case initially, of course, resulted in a reversal of a conviction and a death penalty based on the fact that there had been withholding of exculpatory evidence.
Counsel,
And,
can you cite so that the parties have a chance to read it as well?
it's Kiles versus
What a
Whitley,
dick.
514 U.S.
Whatever
419.
opportunity you could take to interrupt.
514 U.S. 419, United States Supreme Court.
Not that train.
That case had to do with the fact that there was evidence that had been gathered by the state or the prosecutors in that case. And a decade after the conviction had occurred, it was reversed because it was determined that there was important information that the state had not provided to the defense. And it's interesting to note why the Supreme Court found that that information was vital to the defense. And it's basically precisely what we're talking about here. The Supreme Court held that it would have and should have been useful for the defense to be able to establish that the investigation was shoddy. It could have raised opportunities to attack not only the probative value of crucial physical evidence and the circumstances in which it was found, but the thoroughness and even the good faith of the investigation as well. Their disclosures would have revealed a remarkably uncritical attitude on the part of the police. The defense could have examined the police to good effect on their knowledge of another party's statements, so have attacked the reliability of the investigation in failing to even consider other parties' possible guilt. This is right out of the decision. A common trial tactic of defense lawyers is to discredit the caliber of the investigation or the decision to charge the defendant. So this was, and put in context, this was evidence that back then the prosecution believed wasn't exculpatory, whether it was negligently not provided or deliberately not provided doesn't really matter. But the point is that Kiles specifically acknowledges the legitimacy of attacking the police investigation in the form of the negligence of the decisions that were made by the police that were not anywhere within the means or the control of a defendant or a defendant's attorney's investigation into the case. I'd also just point out, I'm sure the court is absolutely well aware of this, that when the state makes a motion for a mistrial and when the defense objects, the standard is manifest injustice. And I don't think it rises to that level. So again, I think that what Attorney Mueller was doing here, very consistent with her entire presentation as to the quality and the integrity, basically, of that law enforcement investigation by pointing out things that were not looked at and were not pursued. I know that there was one, the objection was that it appeared to be bringing Ms. Beecham in as a suspect or a prime suspect, or however Mr. Gravely was concerned about that. I think that's, if there is a concern along those lines, I think that's easily remedied by the very simple instruction that I know the court's given many times, which is the opening statement is not evidence. Ladies and gentlemen of the jury, you're reminded that the opening statement is not evidence. I think that takes care of it. But while we're on the subject, the concerns that the defense has is that this is one of a series of issues that we've been intending to raise regarding the decisions that were made by law enforcement as to what avenues they would pursue. And I think it's very clear that one thing the court could preclude the defense from doing, and I'll tell you, we never intended to do this, is that we can't get up and argue in front of the jury that Sadie Beecham did this. I mean, we would never intended to do that anyway. But if the court wants to order us not to do that, that's fine. But looking at how the investigation was conducted and what issues were looked into, again, evidence raised, which is right within the discovery that was provided by the state here. I think it's entirely permissible to, and the court should allow leeway for the defense to talk about all of the things that happened leading up to where we are today, that are part of the investigation, obviously within the bounds of relevance, but the court's also familiar that, if there is some issue that's being claimed as unfair to the state, the court can fashion a remedy, such as a corrective instruction. The court should also consider, I don't have the site, but someone can look it up real quick, Chambers versus Mississippi, that I know the court's familiar with, that requires the court to interpret any particular rule in favor of the opportunity to allow the defense to present a defense.
You got it.
Thank you.
And let me just put the site for Chambers, Your Honor, 410 US 284. That's from 1973.
Yes, guys, I'm sure Jeff needs sleep, but I'm also sure that he's
Thank
curious to see whether or not we're going to mistrial or not.
Did you need me, Judge? Okay. Mr. Govey?
So, Judge, first of all, the defense did file a motion, a Denny motion regarding Michael Campbell. We litigated that extensively last
Yell
week.
some more.
Both parties did an investigation pursuant to that. And that allegation was completely based upon, as far as I know, was completely based upon evidence provided by the prosecution. So for the defense to say that in this case, they don't need to, that we're on notice because the evidence was already in the state's possession that they wish to use, they didn't feel that that was that precluded anything in the Campbell case, which was identical. I want to tell the court, I want to make the record, this is intentional. The defense in their voir dire chose to emphasize that if you can reconcile the evidence based on any reasonable hypothesis, this was one of the specified questions by the defense. Then I think the transcript is abundantly clear as to what's going on. First, on page 4 of the transcript, defense counsel in her opening describes ignoring legitimate leads and follow-ups and suspicious people. In her very next paragraph, so literally seconds later, she says, so what did they ignore? Again, talking about leads, follow-ups, and suspicious people. They ignored Miss Beecham. So has to be a reference to suspicious people. I'm in the middle, line 15 of page 4. Because Miss Beecham, as the state noted, went to Mr. Gutierrez's residence at around 11 a.m. on May 19th. Remember, she's the first one to find the bloody scene, okay? So casting suspicion on her for having criminal conduct. Now I'm on page 5, the second full paragraph. Sure, there could be an innocent explanation to that, but you'll also hear evidence that Mrs. Beecham had constantly been texting with her best friend, Rebecca Jekyll. So now she's indicating, based on her being the first one to the scene, I want to be sure you know about this texting conversation with Rebecca Jekyll. Then on line 9 of page 5, she says, this is all on May 14th, 2020. She's complaining about it. Text messages between her and her best friend, Rebecca Jekyll, referring to the fact that Anderson, the defendant, is up to monitoring her, etc., but she can't prove it. Her frustration that I can't stop him based on legitimate means is the allegation there. And so then we get down to the crux of it, line 15 on page 5 and on, where she says, Mrs. Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is that it will begin and you will not know when, where, or how. Call me in 1 week. And then she goes on to draw a direct connection.
I really hope I don't miss it, but I need 5
What's
to get the
1
daughter
week
ready to take her.
later? When she's at Gutierrez's apartment. So I don't know how more clearly you could try to line 5 things up in a row to say that these 2 women are part of a conspiracy to have Mr. Gutierrez murdered.
Oh, that's a bit of a stretch.
Mr. Anderson. This is what's being alleged here.
No,
It
really.
doesn't, there's no mystery to it. It connects all the dots and says you just need to read the lines. And it's in the context of saying that it's a suspicious person who should be considered, who should be looked at. So it is, Judge, you heard the argument from the defense that this is based on a defense of errors of the investigation. Okay, and of course that's a legitimate avenue to pursue an investigation. We don't deny that, but that's not an exception to Denny. And if it was an exception to Denny, then Denny is emasculated. The Denny case doesn't exist if a defense attorney, every time they were caught and said, you know what, you're supposed to do a pretrial motion before you accuse someone of doing a homicide in front of a jury without notice. If every time someone was called on, they could simply say, well, I'm just bringing this up in the context of the police not looking at this person, then the whole line of Denny case law is worthless. It's worthless then, because there is absolutely no situation where a person making a Denny violation would ever be able to be held to account so that the prosecution had proper notice, the individual was not being blamed without the court being a gatekeeper, and of course, all parties had a right to a fair trial. Counsel cites one case to the court. It's Kyles v. Whitley, the U.S. case. That's about a Brady violation. It has nothing about third-party liability or some third party being blamed. I don't believe it has any cogent or helpful analysis for the court, but the Denny case is absolutely clear. It asks for pretrial guidance for a judge when an individual has been specifically blamed. Again, Judge, this cannot be put back in a box. There's no corrective instruction that will allow us to correct this. This is why the Denny case is a case that stands for pretrial or before being brought up in front of a jury admission of this sort of evidence, discussion of this sort of evidence. It's so we don't get to this place. You can't give a curative instruction saying, you remember when there was that sown sort of theory of why the person who discovers this bloody scene is actually involved in a conspiracy to kill him and frame the defendant? You can't take that and ask the jury not to consider that now. I don't believe it is a legitimate theory. I think if the court hears us litigate this, you will not think it is highly that it is relevant material to make an accusation that there's a frame up. But we don't have an opportunity to investigate that in short order, Judge. We will need an opportunity, as Denny is supposed to afford, to be able to take a look at this allegation. And at this point, Judge, I suspect there are more of these. And I suspect the careful litigation of this case now is to ask the defense if there are any people they intend to specifically blame in front of a jury, either in opening or closing or during the course of this case, could they please in pretrial motion present that so that the parties can litigate all that matter together? Judge, I believe that's the only course that is allowed. I think there is a manifest injustice that's been determined here by this argument, and I ask the court for a mistrial based on this finding and ask the court to then discuss the speedy trial and how this is an exception to the speedy trial demand by the defendant.
Well, during the break, I
here we go.
reread Denny and
Do we have a mistrial?
and some of the other pertinent cases. But along the way, I encountered a case which has not been published. It's not recommended for publication. It was released by the First District Court of Appeal, well, by the Court of Appeals. First District case. And I'm going to be careful about citing it because it's unpublished and it's not recommended for publication, but it raised some interesting issues to me, quite apart from what the court said. Well, I'm going to cite it for historical purposes, not for precedential purposes. Some evidence came in. It had already come in when The Denny issue arose, and the judge felt that it was,
Oh, come on,
Any
get on
type
with it. I'm going to have a
evidence.
heart attack here.
and said it shouldn't have, the DA hadn't been properly noticed. And granted a mistrial. And there's some discussion in there about what's a manifest necessity. It's quite interesting. There is also the history of the case. The judge did grant the mistrial and ordered a new Denny. Well, it ordered that the defense wanted the evidence and they needed to bring a Denny motion, which the judge heard and decided that the evidence was proper Denny evidence. Now, we talked before the break about the high-risk strategy, and it is indeed high risk. And especially if the judge ultimately determines that it is appropriate Denny type evidence. That cross-examination, because, and I know you're making the claim that this is directly the target of the Denny rule, but either way, if it's relevant examination on the subject to which Mr. Ober had cited Kyle's case. And actually, back there's an 1891 or decision by the United States Supreme Court about the defense right to suggest that the police investigation was shoddy, is the word he used, and has been used at that level. And I'm certainly not embracing that, but that it was not a satisfactory from the standpoint of proving beyond a reasonable doubt that the defendant is guilty. So I'm going to repeat that this is really very, very high risk, because if it turns out, as I said, that this would be legitimate questioning, quite apart from what's been stated at opening statement. And a mistrial is granted over the objection of the defendant. It is, the case is likely over. Likely over. And as far as opening the floodgates,
Walked in
that
just in time to hear the
actually
words
is discussed.
"mistrial is granted" and freaked the
It
hell
has
out.
been in cases before. In fact, I think it was discussed in the Denny case. But the state can file a preclusive Denny type motion or a demand for some offer.
I just kind of
proof.
swore there.
And
Good thing I was muted. I've been screaming, get on with it, get on with it, get effing on with it. And then, like what you said,
determine pretrial. And
just spit it out.
so the burden is not entirely on the defense. I made the comment before we broke that, and I'll stand by the comment. And
Not as of yet, Alex, but it
I
looks
made
like
my
he's getting
ruling
there.
on the Chapman.
Scared me.
Campbell. Michael Campbell.
I didn't feel that the defense had presented a strong enough case of legitimate tendency, as it exists in Wisconsin. This is paragraph 12 of, we didn't cite the cases that way in those days. Well, yeah, I guess it is. It's
Thank you,
page
Crystal, for the
12.
5 memberships too.
Thus,
I appreciate that.
of the Denny case, in the Callahan's reporter, thus, as long as motive and opportunity have been shown, and as long as there is some evidence to directly connect a third party person to the crime charged, which is not remote in time, place, or circumstances, the evidence should be admissible. By illustration, where it is shown that a third party not only had the motive and opportunity to commit the crime,
Okay,
but
I think
also
he's laying
was placed in
foundation
such
here by saying that
proximity
he
to the
would have
crime
granted the motion if it had
as
been brought to him.
show he may have been the guilty party, the evidence would be admissible.
Yeah, but that didn't happen. What did happen? Tell us how you're
Or
going to
where
rule.
a
Just
third
spit it
party
out.
has committed or actively seeks to commit violent acts against the victim, or has threatened the victim in a manner not remote in time, place, or circumstances, evidence might likewise be admissible. Yeah, I commented last week, I didn't think that the Campbell, thank you, case met the standard from what I've heard so far. And I'm not, this is not a ruling. This would be a much
Get to the
stronger
ruling.
case for the defense.
Yeah, I maintain a high degree of confidence that the court's mind will change when the court hears the circumstances, but that will be.
That was the mistake that I'm
Yeah.
not commenting for presidential purposes, but that was the mistake that the very good judge in the case from last year made.
Even though that mistake was made previously, I maintain a high degree of confidence that when I have an opportunity to appropriately investigate this, and the court hears the factual circumstances of this certain scenario, just as the court did in Campbell, the court will find this to not meet the standard of Denny. I have a high degree of confidence of that the court will not find a motive and will not find circumstances that are worthy of a jury actually hearing that accusation made. And I fear that there are additional candidates for Denny consideration. And so, yes, I intend now, I evidently was fooled by the idea that a Denny motion was filed against one individual. And maybe that is my error. Maybe I should have understood that when defense counsel chose one person to file Denny and then made Denny arguments on another person, and I believe intends to do additional based on the representations they made previously, I didn't know that they were only going to litigate one and not others.
Well, I'm not suggesting you did commit an error.
Well,
You did not, we're not on the same page. No.
I've never filed that, never filed a pre-Denny because I've never faced defense counsel before where I felt that was enough of an issue that I would, but I certainly will this time. And I certainly adopt the court's idea that in certain circumstances, when certain things have happened, that the state has an ability to force this litigation to occur. So I'm going to do that. But Your Honor, we are in the same boat here. I don't know who will be the next argument that is made. This is an argument that cannot be taken back from the jury. I am requesting a mistrial, an opportunity to do.
I'm requesting you shut up and let the judge rule.
And have the appropriate Denny motion filed, and then let's litigate this.
Judge, if I may.
No, Judge, we can't have multiple attorneys.
Well, my feeling is.
No.
The
Why don't you let the
reporter-
judge say
trying
no?
Sometimes it's just a constant barrage of remarks coming from one table or the other. And the reporter can't be expected to handle that. Where it's segregated enough, would it present a problem to have another lawyer address this? Okay, go ahead.
Thank you, Judge. And I'm not trying to barrage. I've been quiet as a church mouse, as you saw. So So Mr. Gravely's wild imagination about all these Denny motions
You
that
need to
are,
have the adjective in there.
I'm sorry?
You don't need that adjective.
Okay. The imaginative discussion about this
You're
motion
kidding.
that he thinks is coming is
You know what's going to happen. On this, I've decided
it's a little bit
it's gonna cut out.
mind-boggling because he now says that after hearing this text that we got from him, Judge, that now he wants to go investigate, and then he's confident that he's going to prevent a Denny motion or defeat one. Well, we've made it clear we're not doing a Denny motion. We're not doing one. If you read this, the context of this transcript, it is Ms. Mueller saying the police investigation poor here. They missed this. They missed this. They missed this. And then she talks about the transcripts. The texts. And so, and if you remember, Judge, during our last trial in this courtroom, it was the state that suddenly had some information that had come out during his opening that we found out about. That's what caused the mistrial then. And then following that, with quite a bit of litigation to follow, they did their investigation. They followed up on that investigation. So it's the same refrain right now that we're hearing from the state's table. The exact same thing. That they're caught flat-footed about stuff that they should have known about, and we're calling them out on it in our opening and in our argument. And that's what this whole case is about. This isn't about 10 different Denny motions. If we wanted to bring 10 Denny motions, we would have brought them. I think this court has seen that this defense team has been absolutely meticulous about bringing things to the court's attention, about litigating things properly. There's no misconduct.
It's
here.
5:30 in the
There's nothing
morning. Give me a
and there's
decision.
no attempt to bring a subvert Denny motion. And the accusation, it seems almost like the state wants to take this case.
Yeah,
because
no, we don't
they
want to
know
do this shit. Are you
that it's
kidding me?
weak.
Mhm.
That's what it looks like from the defense table. So I'm going to ask this court to deny the motion, instruct the jury to say, just like Mr. Robert was saying, to say opening statements are not evidence, period. Okay? And then we'll finish our openings and we'll get on with it.
Listen to him, Judge.
The particular problem for me,
Oh,
one of
God.
the particular problems for me is, and I'm sure I commented about this before lunch, is I certainly agree that it's our law, and it has been for a long time in this country, that the defense has the right to pick away at the caliber of the police investigation. And some of the points that have been raised by Ms. Mueller have been along that line, and this is certainly one of them. At what point does the camel's back break? At what point does legitimate picking at the caliber of the investigation become an accusation of another? This would not be this big of an issue in the case if this just arose during question and answer of a witness, and there being an objection, and then they have to make a contemporaneous ruling, and we might never even think of it in terms of Denny type motion. But unfortunately, I understand your position, and I wish this weren't arising now. But
Thank you to the 23 of you also watching on Rumble.
The additional weight of the additional issue created by this messaging, along with the features that go with it, or did break that camel's back. And what do I do when this issue arises in opening statement? Do I say, if I think that this evidence is going to be admissible, do I rule without considering its cumulative effect, which maybe deciding it is Denny material, or and that's what you claim, because you say in the end they're going to be pointing fingers and citing all
The
this
Mithril
evidence.
King is. You can tell Vice didn't
to
actually
your
watch
point,
the
that
trial. He
it's
was like this
Denny
there
type
too.
evidence.
Of course, I watched
or I
the
can hear
trial.
what,
The point is, we've been waiting almost
the defense
3
is saying.
hours now for him to tell us whether there's going to be a mistrial, and we're done with this. Just tell us, and then give us your reasons.
Just let it in as evidence to
Yep.
support their claim that the investigation was not properly done.
Well, Judge,
Now, here we are, because it arises now, we have this big issue right at the beginning of the trial, and the jury's been told you have 2 weeks, and maybe an extra 2 days beyond that, and we got to get this case done. And I think, well, if anybody is talking about adjourning this case for more than a day,
I just want him to get on with it, honestly.
the answer, unless you have some compelling reason I haven't thought of, is going to be no. I have no desire to mistry this case, and because I do think that taken individually, and you know, as I think I commented yesterday, or maybe in the motions last week, you people, lawyers in general, come to court thinking that the judge has this enormous wealth of evidence, knowledge about the case, and that is very untrue. I don't doubt for 1 minute that every one of you has 10, 50, 100 times more information about this case than I have. Judges very seldom see much before the trial starts. So you say this is, you suggest that this is all going to be easy to destroy, these points that the defense is raising. Well, I don't know that. And,
Judge is going to get in trouble.
So, and then it's all going to turn into a massive Denny type attack. I don't know that either. So I have to make rulings on, is this legitimate inquiry into the caliber of the police investigation? And
so can I just say,
Yeah.
Miss Jekyll, the person who's texted back and forth, is on the defense witness list. She's been served by the defense. So this is not just an innocent kind of, well, why didn't the cops do this inquiry? This is a subpoenaed witness.
Dude,
shut
up! The judge has already
There's no
decided.
other reason that I'm aware of that she's a witness on their case.
We
Judge,
get it. Your
I
butt
don't
hurt
object.
because you didn't get your
why did you think
chance.
she was on their list?
Enough.
Well, because they have subpoenaed 150 people, and because of those 150 people on their witness list, this is a dear friend of hers, and that they have not spoken to her. They've had no conversation with her about this case. They have, when she, my understanding, again, this is anecdotally, is when she asked why they wanted to talk to her or why they wanted to subpoena her, they did not provide information regarding that. Judge, I did not object in this case and say to the court that I needed to object based on Denny until point number 5 of this transcript came up, which is drawing the line the full circle. So said, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And then the immediate answer to that is, what's 1 week later? That's when she's at Gutierrez's apartment. So it is a suggestion that goes full circle from beginning to end.
Shut the fuck up, Danny.
Your Honor, I believe Your Honor is I believe, Your Honor, is presenting the parties by saying, yes, a Denny motion should have been filed. I think the court is saying that. I may be misunderstanding the court. And there is no remedy at this point for the court. I'm not asking for an adjournment, Judge. I am telling the court improper information has been provided because the court has not heard this in the way that Denny intended. And it fits all of the qualities. This is not just a something that came up in the middle of trial under somebody's questioning. This is a deliberate presentation. This is an argument structured by a lawyer that began by saying suspicious person.
Am I the only one around here who gives a shit about the
To
rules?
discover Rosalio Gutierrez's bloody crime scene.
This is how you know that Jeff and I are just
Text
over it.
with
We're having a
her,
battle of sound
conversation
effects.
with her friend or dear friend on our witness list, turns out. And you,
Sorry,
and
Jamara.
mystery, it's been taken care of. Call me in a week. And then guess what they say happens in a week? She shows up at the apartment and finds the crime scene. She's described as a conspirator.
I've already stated
Basically.
that I
Yeah.
thought
And so,
this was a stronger case than the case found.
Or she just said,
but the court
naturally, the
has
person
not
that
heard
found
the
it, you
Denny
interview
criteria.
them, you
The court
question
has
them.
heard one very specific set of facts without the state having any ability so far to respond.
That's where, no.
Okay, and
Here.
and the court is.
No, Mr. Grable.
I apologize.
This is the mistake that a very capable judge in Milwaukee made that I've mentioned. Should have waited till the smoke cleared. You made the statement before, there's no other remedy. That's not true.
Oh,
Some of them are not remedies I particularly want to do, like telling the jury, guess what? Your plans are all off because you have to sit home a day or two while we deal with some legal matters that have just come up. I investigation and resolution have got to take
Today, Junior!
or 5 days.
I'd like to thank Unsung Hero for the super chat and the suggestion.
And we squeeze it into 1 day. And I don't think that I don't think it's outside my power to command the defense if they have any that they need to communicate them to you by 9 o'clock tonight or something. I don't know. And save the trial. I think that declaring, I think ruling this a mistrial on the basis of what's occurred here, without knowing whether this will ultimately all be determined to be admissible, which is one of the mistakes that my friend made, and making a determination that something was a manifest injustice when there were other
We can only
things
hope,
that could
everyone.
have been done. I think that's a mistake. So I'm not asking that you agree with me or change your mind about anything, but I want to hear from both sides here.
Oh, Jesus!
Without ruling on the pending objection, I'm thinking in terms of sending the jury home until Thursday. Today's Tuesday, right? Thursday, and then we'll pick up from this point, and at that time, I'll either sustain or overrule your objection. and me direct Ms. Muller to move on to another subject.
Fuck you.
We'll have,
With all due respect, Your Honor.
I've already canceled or in the process of canceling what was left on my calendar for tomorrow.
So,
And so I'm available to hear these things and determine them. And then I won't get in the boat that the poor judge in Milwaukee got into.
so
Well, if I could, Judge, I think.
Well, yeah, you did speak first. Go ahead.
Yeah, I guess I'm a little confused about what it is that the court is going to wrestle with in the next day. Because if it's, well, I'm going to listen to the defense's Denny motion, there is none. So,
Constructive Denny motion.
I'm sorry?
Or do you prefer virtual Denny motion?
Okay. All right. Well, if that's the case, then maybe we need a week. I don't know, but
Well, you're not getting one.
I know.
Uh-huh.
So what you're saying, this is, I just want to understand where the court's at. You're saying you want to have a hearing on what was said in opening in the greater context of what the actual evidence will be?
Well, what was said at opening is significant only because it creates the problem that I was
For the next 2 days, we'll be going back to the XXX
discussing
Investigación
at the
trial.
beginning, that this is time for something like this to come up. And that's really not the focus. I mean, if there's a misstatement made at opening, it can be dealt with, whether it's by a corrective instruction or whether it's by a mistrial.
Oh,
It's
come
very
on,
clear
Lauren
he's
Cuck,
willing
get
to
your
run
shit
the
together.
risk. The issue is he's painted this
Both. Go with both.
portrait of
Both is good.
what he thinks is unquestionably any type of evidence being used for the very
Your business is in
purpose
Maine
of
now, isn't
the
it?
Denny rule.
There's a competency hearing March 6th,
Okay.
and it's tentatively scheduled
I
for
read
May
it before.
15th.
And did we get a hearing date for the other one that got postponed? Because I think that was supposed to be yesterday,
Ultimately,
wasn't
I
it?
need to make a ruling whether
Like right now,
can-
today. Let's see.
present your Denny type evidence
Oh, yeah. Sorry. It's today there.
either as a full Denny attack or
Oh, yeah. That honestly, the jury find out that the prosecutor's the one that did this.
truncated fashion.
The jury's just going to
proper
rule in their favor for the
cross-examination,
sake of
but
it.
not suggesting an alternative actor to the jury. So that's the big question, and that's where I said that's where my friend strayed is he declared the mistrial before he had the Denny hearing.
But Judge, why would they file a Denny motion when they've already accomplished what they wanted to do? The jury has heard this information. Again, this
But
can't.
if I decide that the Denny motion is granted,
Yeah.
then they're going to do exactly what you most fear. Is they're going to present an alternative actor defense. If I say that they are
Thank you, Desert. I
that
appreciate
the
that.
evidence does not support what you claim to be an alternative actor theory, then, as I said, they're either going to have to eliminate or truncate the evidence that they were going to offer that
Come
would
on.
constitute a Denny type.
What? Just
evidence.
tell us what we're gonna do. Send us home.
Okay, so what has been
I feel free to say I don't know what you're talking about.
well, I'm just trying to figure out. So I don't see any motivation for the defense to file a motion. I think they've clearly stated they don't wish to or intend to file a motion.
Then just fucking get on with it.
If I could file something, and I think the court is telling me that I would have a portion of a day to provide the court a response. I think that's the guidance. If I understand where the court has told me we're going, and that the outcome of this, when I have requested a mistrial, is that there would be the court believes that perhaps some cautionary instruction would be the remedy, or they would not be allowed to pursue this in other.
To be fair, I was covering it for a little while there.
Well, the bottom line is this is going to defy any precedential solution. I don't think this has ever happened before. We went through that on the Campbell case, where you couldn't find any authority other than down south.
Right.
So the worst to me, I'm standing at the edge of the Grand Canyon, and
Jump.
You're
a cannonball.
You're asking me to take the high risk that you're going to be able to knock down this this Denny notice that they've not given, and everything will be fine. That's what happened to the poor judge up in Milwaukee.
And in that case, Judge, just so that we understand the historical reference that I think the court made to us, are you saying that case was dismissed without prejudice?
When I'm talking this secret case I'm not naming?
Yes.
Dismissed with prejudice.
Okay. So
by the Court of Appeals.
Okay, because I've
Dismissed
litigated
without prejudice by the trial judge.
All right, so I've litigated this issue in our courts here in Kenosha before, had it gone to the Court of Appeals, and did not have that outcome. This was several years ago. It was in front of Judge Milosauskas, but I had a case in our county where this occurred, and not where Denny was granted at the end. So I understand that would be the distinction.
Is it reported?
No. But it is a case that I had. I had it with one of the Jensen co-counsel from the public defender's office, who's still
all right. It's been an hour.
Office, but she, in an opening, did the same thing. But again, I'm not citing it for presidential value. And again, I did not have a post.
Jury's going to be pissed.
Mistrial granting of the Denny. So it wasn't. I think the court is adding that aspect.
Well, if the judge in the case I've spoken of, had not made that determination.
Deb Hackney, please tell me what's happening. They're arguing over whether or not to give a mistrial.
What the court has before it right now is an offer, what I would call a Denny presentation by the defense, where the theory that is proposed is that this person, from my perspective, what has been argued to the jury, I know the defense says, well, we didn't argue that, we just argued bad investigation, right? But what I believe has essentially, what we know, points 1 through 5 that I cited earlier, is that the idea is that a person who is having an active relationship with this individual, who on May
Kill me now. Play, damn you. What? Am I gonna have to refresh this?
Yep.
17th,
Nope.
the very same day that she has contracted for his murder, the day before she has visited his children for the first time.
It was them.
And the day of,
feeds buffering. I like
she
that.
is literally texting him, I want to take this relationship farther. I'm hoping we can take this relationship farther. Where in the meantime, she has conspired with her friend to have him murdered, not because she has anything against him.
I tell you what, I've heard so much about Denny's in this. That better be damn good food.
As a means of framing his ex, because she is frustrated that he is monitoring her in some way she can't prove. That's the factual circumstance the court has. So the motive the court would consider.
I'm back at the same place I said before.
Yeah.
I don't have all the information that you do.
Right.
So I don't know.
That's my point, is that
And
I
I'm not-
haven't had a chance to make that argument to the court because we didn't have a Denny motion, right?
All right,
where
that's
we would in a
fine. And
pretrial
I've
motion.
told you we can have one now. And I don't know what happened downstairs in that other case. And I don't know anything about it, and it's not reported, so.
Sure.
Well,
But let's hear from the other side.
just Judge, I don't know how much a briefing or whatever needs to be done on this. I think if we print off the entire transcript of Ms. Muller's opening, so you can see the entirety of these very tiny comments in that whole larger context, it will be pretty clear that what we were saying all along is that this is just about a shoddy police investigation. It's not trying to point a finger at a third party. We would have, if we wanted to do that, Judge, as you well know, we would have done that.
Well, I have the good fortune that I have a splendid court reporter who came into my office right after we broke and said, would you like me to go back a little further? And I said, well, yeah, if you've got the time. And she presented me with a longer transcript, so I have a better idea. And I was listening, by the way.
Yeah.
But
I think that'll make it pretty clear. In other words, we don't need to have some big factual presentation beyond what's in that transcript. It seems to me that that's going to clear this up for the court.
I'm not going to comment. I don't know what the future holds. I certainly wouldn't have.
Well, let's get to the future.
When this day began, that I'd be dealing with this issue right now. But consider yourselves as having filed a Denny motion on with respect to Ms. Beecham. And if you have any others who need to state those, what did I say, 9 o'clock?
Yes.
9 o'clock by message to the district attorney, electronic, and to me. And the DA can have until well, we'll start again at 1 o'clock tomorrow. And I'm not going to put a deadline for you to file a written response. You can just.
How thick is his phone?
Start with legal arguments at 1, or
We're going to
start
start
with
with
the jury?
whatever anybody wants to say on this issue. I assume there's going to be a lot of legal arguing, but if you want to offer testimonial evidence,
Don't you fucking dare.
we'll do the best we can.
So today, I believe the court's denying my motion for a mistrial, if I
No, I'm
understand.
Yes.
I mean,
I want to get all the
provisionally,
facts.
For today.
provisionally,
I wouldn't say that.
okay.
You're not going to rule on it today.
I would say,
You're not going to
I
rule
wasn't
on it
trying
today.
to cast
No,
aspersion in
no.
any way. I just was trying to interpret how the court is, where the court is
Well,
postured.
Fuck this shit, I'm out. Fuck this shit, I'm out.
I have not made a decision
Okay.
on that, and it,
And that is what we're litigating in part tomorrow at 1 o'clock. Is this issue of
and
whether,
I assume I'll make some decision about whether we go forward or not and under what circumstances. And give you some guidance about what and would and would not be acceptable evidence out of what has already been mentioned.
so of course, we're going to start having witness crunches, and the court, that's not the court's problem, but it is ours. So am I to have no witnesses available tomorrow? They would be, my witnesses would again be available for Thursday? Is that my guidance?
Yeah, because I'm not going to have the jury come in tomorrow.
Okay. All right. And so we will litigate my motion for a mistrial as well as the Denny issue at 1 o'clock tomorrow. Do I have that correct? Okay.
And if anybody has a witness who is absolutely positively has to be heard tomorrow, tell me that right now. Because it's not that I can't have the jury come in, but at this point, it doesn't seem there's any sense of it.
So Michael Campbell is a witness who is headed to Florida on a planned vacation. remember Michael Campbell? We've mentioned his name a few times. So he is headed for Florida on a pre-planned vacation. He's leaving on Thursday to go on that vacation. I just asked if we could figure out when he gets back. I don't know if we know that. Okay.
Well, Hayden, we know it's not over. 5:51
How
a.m.
long it is?
I'm gonna go to sleep.
I was going to say, get some
He's the
sleep
only
as to
one
what
I
you
know
can.
is an issue for
It's
Thursday.
a
you.
holiday
I'll see
today,
you.
so I get to sleep in.
Oh, so you don't actually have work. Congratulations.
No.
That's probably for the best. That explains why you're still here,
Yeah.
actually.
Yeah.
Holy hell.
Thanks, everybody. I'm done with this thing today. And this doesn't, I mean, if I wasn't just so anxious about whether or not there's going to be a mistrial, this would probably be a really fascinating discussion.
Mm-hmm.
But I just want to hear mistrial or no mistrial. I don't give a shit about the discussion at this point. I'm a bad person. All right. I guess Ozzy will take care of you tomorrow for the afternoon session.
Or maybe like when that transcript would be done,
Can do.
if that would be done, so we could work on it tonight.
Guess I can do some Murdoch until I have to go to sleep. Yay me. All right, everybody. Thanks. We'll see you, I guess, in 2 days.
You don't get
What,
service
Desi, you mean
that
this one?
everywhere.
See you, Jeff.
And by the way, Aussie needs like 70 more people to get to 9,000 subscribers.
No shit. Did I get that far?
Okay, so we have a witness who will
Make sure you subscribe to him and give me a thought too if you haven't already done so. Pop on over to Legal Vices and give me a.
Look at that, 61. Surely there are 61 of you watching that are not already fans of me. I'd very much appreciate getting to the 9K.
that we know is an issue for Wednesday.
Okay.
We'll see y'all.
Defense, any
Bye.
witnesses?
Sorry, I just wanted a clarification on what exactly the court was ordering the defense to provide by the state. And I'm assuming it was by 9 p.m. or 9 a.m. tomorrow?
Was 9 p.m.
Okay.
and it was any person.
Eyedrop Lady was postponed. We were supposed to hear sometime today as to when it's going to be rescheduled for. We will keep an update on that as well.
Proposed to offer alternative actor evidence in terms of
2 hours. We've listened to him for 2 hours, and he's going to keep going, apparently.
Gutierrez. The state says there are all kinds of people. I have to tell you, I deal with a lot of people with bad reputations coming through here over the years. And this is a first for me to have that many people who would be considered as.
No shit, really?
You said there were going to be a large number of people who were going to.
I thought I heard a representation. I was basing that simply on the defense indicating that they had some more people that they were about to make a similar argument at the point that I objected. It was just based on the defense, I believe, indicating that, and the track record of Michael Campbell indicating that we had a motion, and then this case where
that could well be the case, Jim. In which case it'd be very interesting.
Sadie of being a suspect in this homicide. Counsel discussed what he thought was mind-boggling. This is my mind-boggling episode. So it
I'll probably do triple X in the morning,
the number of
maybe if I'm
who I
awake,
see as
and
potential
do the afternoon
suspects.
session of the arguments.
That is the quality of the theories that are being provided to the court or to a jury. So I rhetorically said that it appeared to me that there were a number of others, but I may be wrong. They may provide no additional individuals, which would be fine.
So what it sounds like, the state would like to take all of the points of the investigation dealing with particular individuals and reframe those all as Denny and get you.
I'll come back to this, Valhammer. I'm going to star it, and we'll talk about it
they
when
don't
we
have
get
to
through the
worry
super
about
chats as well.
That's what I'm hearing. Because Mr. Gravely keeps saying how we are accusing her, and we've repeatedly said
hell
here
no,
in open court
I'm reaching for pills at this
that's
point.
not the case. So
No dose.
you could have a
Caffeine
reasonable
pills.
you know, we could look at this transcript and the court might read it one way, Mr. Gravely might read it another way, we might read it one way. But at the end of the day, there's not, you know, he can't just ask this court to look at every single point of criticism of a shoddy investigation and call that Denny.
Without
not the case.
responding to your comment, I would just say that if you do not supply the state with the information about people who would fit into, we'll call it a near Denny category, don't count on any of that evidence coming in. The law is there, the notice required is there, and it hasn't been given, and if the circumstances don't require it to be given, then you're in the clear. But if it turns out it fits into that category of any evidence, it's not going to come in.
I think
Right?
we have guidance. Is the jury back? I assume they are.
Well,
I certainly hope so.
Okay, so
I could use a little more guidance though, because perhaps what you're asking of the defense then is for us to bullet point for the court each of the points of our criticism of their investigation and who's involved. Is that what I'm hearing?
No.
No? Okay.
Well, you may be hearing
think
that.
he's got a
but
grudge,
That's
to be
only
perfectly
your
honest.
imagination. at work.
Okay.
I did not say that.
He screwed
Well,
up the
I
case
would
the
just
last
like to
time
know
and
what
caused a
you would like to
mistrial.
see.
Yeah.
And I think he's doing what he can to
I actually thought it was clear.
get what
If
he
I-
can out of
if
this,
I
frankly.
can, my understanding of the situation is that you would like the defense to provide, if we're going to have any other named individuals who we intend on presenting in the same way that was presented as Sadie Beecham, that those people should be provided to the state by 9 p.m.
Let's do it this way. Let's just pretend that I tell you, you need to comply with Denny, the Denny rule,
Yeah. So
Which
file
kind of a
Denny
tendency?
motions.
except that the provisions that you bring the motion and have it heard before the trial have been changed to tomorrow. That's what the order is.
So who they are and what the factual circumstances are, then meet Denny.
I think
what I
that's, I think that's fair,
Thank you.
right?
Coming for the creators, not the case. I'll
Well,
say,
let's get the
like,
jury down.
12 years dropped away when Jeff left, so I can understand that. The court reporter looked direct. Wait, is that the court reporter? She looked directly into the.
Hello.
Would you come down, please?
Yes.
Clip this section if you're having insomnia. Look, it's been entertaining, but yes, it's clear as mud or the Ohio water. For anyone that still doesn't know, I know that there's 240 of you watching, so I'm just going to say it. We've been making sure that the Ohio train derailment isn't strictly out of the news sphere, because it does feel like a little bit it's trying to be buried a little bit. But there is still shit going on there. They still have rainbow-colored water flowing through that creek. So, river. So. Just dropped in, same judge from the Rittenhouse trial. Yes, it is, Tina. Absolutely. And we've just spent 2 hours listening to them go back and forth about a possible mistrial. And it sounds like if she complies with the Denny obligations, that I'd be filing an emergency appeal because the state's completely stripped away their ability to cast doubt on the investigation, and the judge.
All right, folks, I apologize. This happens rarely, but it does happen where the legal issues get very, very involved.
Basically, it's
And
kind of
there was an objection made. I'm going to stop it right here. I'm not going to rule on the objection right now because actually I'm going to take some more argument and perhaps evidence tomorrow on some issues. And that will hopefully assist me to resolve the issue that's pending because of the statement in the motion which was made. We have a very shortened schedule. These are usually things that are done prior to the trial, but and we're going to condense them into one day tomorrow. And the good news for you is you don't have to be in on it. So I apologize. I know it's disruptive to your schedules. And of course, it means that the case may go longer. But I still hope to finish within the 2 weeks and
Tweety, this
days,
actually works in my favor because it means I can get on the road to my
Hope is
regional
the outer
office
limit.
without
but
missing too much in the trial. So what we'll do here,
this
guys,
may
is
resolve a lot of
once he's
issues
done
in the
talking,
case,
I'll run through the super
for
chats
the
and the starred things,
hearing
and
tomorrow.
then I'm probably going to hit the road. But we'll
So I'm
definitely be
gonna ask
back
you to
for
return
1 o'clock tomorrow for the
Thursday,
afternoon session.
9 a.m. It is critically important that you not read, watch, or listen to any account of the trial. Discuss it with anyone. It may or may not be available for viewing
No, he's not planning on.
on the internet or
At
television.
least
or
not till
anything.
Thursday by the sound of it.
But it's not available for you. Believe me, that's totally critical to.
It's a
this
very good
matter
point,
being
Musings. I would
resolved
agree with you. I do think he's
fairly
roped into a
before this
corner.
jury. So do not read, watch, or listen to any account of the trial and don't discuss with anyone. And does anyone have any questions? Okay, so keep your minds open. Don't make any final conclusions from what you've heard so far from the district attorney or Ms. Mueller.
For those of you that are on the way
And,
out,
we'll
just
pick
hit the
up
like button if you wouldn't
again
mind.
on Thursday.
And maybe consider subbing
Thank you
if you're
very
interested.
much. Yeah, have a great day.
No shit, they did their own autopsy? Huh. I'd love to know what the hell is going on with the audio. Okay, so what we'll do is we'll start running through some of these tubish soup. Oh, no, he's talking. Never mind.
Nothing, Judge. Thank you. Thank you.
Dear damn Ryder, thank you to the 20 of you still watching on Rumble as well. I very much
Judge,
appreciate that too.
do you want me to-
Okay. So that pretty well does that. So let's have a look at some of these because we've got 16 of these here. What does your business? Hello, Unsung Hero. Thank you very much for the $5 super chat. I think that was just you saying hello, but I think your business, Jeff said that there's a competency hearing in March, so we'll see what happens there. Lazarus says, damn you, Vice is forcing me to sub to a new channel. Lazarus, I'm very happy that you have subbed. Very much appreciate that. For anyone that doesn't know, I usually do a 2-hour show roughly on pretty much every day at 4:15-ish. Sometimes runs different times because it's like 8 a.m. for me. Where we cover everything law, news, and laughter related, which is literally why it's called Law, News, and Laughter. So what do we got? Oh, I think I can probably just take that off now. Oh no, they're still going. Okay, never mind. He's not guilty. Don't you know? Thank you very much for the $2 super chat. Pigs of the Dirty Van is sus as fuck. Well, we shall soon find out. Very interested to see that. Thank you for the £2. Flux says Mocha Dick Poon. Fair enough. Eva, justice for Hayden, no mistrial. I'd very much appreciate if there was no mistrial. You know, three trials in a row would be a little bit of a pain in the backside. Just began looking any financial witnesses yet? No. Thank God for that. Thank you for the 20 SEC. That's not Corona, that's not sure. Except for the hundreds of prisons where inmates immediately ask for papers. Yes, as I said, so being a what we affectionately refer to as a twisted fucker is not going to help you in prison. Absolutely not. That and wife beating are the two that get you really messed up. Half beat Overlaw'd. I think it's coming in quite nicely. I mean, I had to do a little bit of a half shave this morning just to clean it up, but anyway, thank you very much for that, Flux. Got to admit, this is way more interesting than Murder already. Well, apparently Murder got a little bit interesting today, so we'll certainly see exactly how that goes. Saying sounds like a mistrial. Well, doesn't sound like it now. If he comes back and says it's a mistrial, I will have significant questions, and I think that the defense would do well to lodge the interim appeal just so that it's on record. Just want to watch a trial. Yeah. Which, if this goes to hell, I will be going back to the Triple X Tentacion trial. For anyone that doesn't know, Triple X Tentacion was a rapper. He was shot, 4 guys in a car, stole 50K. It's been moderately entertaining in terms of we had some witness intimidation. We had one of the witnesses blow the door open in something, and then the court ruled that it wasn't, and then that of itself was interesting. But yeah, so there will be trials to watch. I'm also looking at certain historical trials, just in case. Need the Billy Madison Today Jr. clip. Well, we got it. Thank you very much for the suggestion there and the $5 super chat. Schrodinger's ruling. Yes, he just did not seem to be able to make up his mind at different times, which was very frustrating. Thank God Vice has picked a speedy trial. Yes, there is that too. Now, this one from Valehammer. If the state had all the evidence already and didn't investigate these people, how is this even a thing? It is their fault, right? Well, I mean, look, the state can pick and choose as to what they do and don't investigate. That's not necessarily the right thing for them to do, though, which is why you do have the Denny motion to try and be able to point the finger at people that the police and prosecution didn't properly investigate. It sounds to me like all this could have been remedied by a formality, basically. So I do very much expect that. Well, I mean, the judges more or less ruled it that if they comply with the Denny requirements, aside from strictly actually providing a Denny motion for the court, because that's basically what he said. We're going to take it from pre-trial and put it in the middle of trial, which is effectively what opening statements are. It sounds like he's going to rule to allow it. So I don't think we're going to get a mistrial at this point. I don't. And it sounds like he wants to avoid the issue going forward. So it'll be very interesting to see exactly where that gets to. Now, see that some more chats came through. Let's have a look. Had to because the lady was crazy and didn't know what she was talking about. Must have missed whatever that was involved too. Oh, they tore her apart instead. That's what you meant by doing their own autopsy. Okay, they tore apart the expert. Okay, clever. Fair enough. Coming in to say hi and like, keeping up with the murder trial at the moment since it's picked up. No, fair enough. Probably give me something to watch on the way to work, frankly. He hasn't decided. The jury's been let go until Thursday. There's going to be arguments tomorrow starting at 1 o'clock. So I'll pick up the afternoon session tomorrow. And I will try and work out exactly when that's going to be. So I'll set that up probably this afternoon so I can work out timing and whatnot. Because I really need to get ready for work. So close to March for necrophiliacs. She business tried to take a lawyer out the other day in court. Yes, which was... Look, it was... He'd probably consider it upsetting. I thought it was a little bit funny, not going to lie. Especially the way that the bailiff reacted. What's extremely odd is that police never investigated the person who discovered the crime scene. I agree with you on that, Jim. I think at the very least that should have been the first port of call in terms of that. So, always a main suspect until ruled out. They just took her word about it. Yeah. And what was really surprising to me is that when he called 911 because those 2 guys showed up at his place, the cops showed up to arrest him, not the guys that were potentially trespassing on his property. that sort of rings certain alarm bells with me as well. Just don't miss Kinky Corner. Yes, I know, I do need to do a makeup Kinky Corner. We're still getting Law News and Laughter today? No, we won't be able to. Sorry, I've run out of time. I've got to head off to my regional office, which, for anyone that doesn't know, is a 4-hour round trip and 350 miles that I've got to travel. And my assistant managed to book someone in at basically the first thing this morning when I get there. So I really have to fly. No laughter for you. Taking motions, correct, or a brief? Motions, I believe. $5 for over 1,700. Deaf Fishy offered a neighbor $1 for 5 acres and they laughed at me. 2-day hearing in the middle of opening statements. The Aussie curse continues. Fuck you. G'day, Val. Missed hilarious shit in the murder trial. That sucks. Oh, he had Barbie lawyer. Okay. Cheeseburger. I miss Cheeseburger. I hope Cheeseburger's doing okay. For anyone that doesn't know, Cheeseburger was one of the 4 guys that was involved in the XXX shooting, and he's a big boy. He was one of the people that was affectionately nicknamed in that trial, and he's the one that we're pretty sure is not going to live because, you know, snitches get stitches. So, just want to watch a trial without bitching prosecutors? Yeah, I get that. Yeah, fair enough, T-Rex. At some point, I will be going back and doing reviews of it, but obviously, if you want to watch it as close to live as possible, then go for it. Prosecutor is definitely nicer to look at in the XXX Tentacion trial. Look, Mummy Esquire. Quite nice. Yep. You meant listen to on your way to work? Oh, yes, of course. That's what I meant. I think the judge has already caused irreparable harm to the defense by compelling them to produce their entire defense to the prosecution. I don't know if he's gone quite that far, but I mean, at the same time, yeah. I mean, even if the prosecution knows the entirety of your evidence and your strategy and that sort of thing, you can still put on an effective defense. And if that's what it really comes down to, then they've just got to do their best and maybe use it as an appealable issue. What was that? Cheesehead lost on Bourbon Street, member of 6 months, says, "Oh my god, 6 months, you made the news enjoyable for me. Thanks a bunch." You're very welcome. That's basically what I do, guys. I try and cover the news that you don't necessarily hear on the mainstream. So, must be an extra special to make up Kinky Corner Brewing. We'll get there. We will get there. I think it's actually 4 now. I've really got some time to make up on that. Snitches end up in ditches. This is true. Peels are for losers. Book of Bronca 316. Yes, guys, if you don't have a copy of this, damn it. Screw it. Anyway, it's Bronca's book. As it turns out, you can actually break the system and get that shipped internationally if you want to. So, all right, guys, look, I got like 45 minutes to get myself dressed and get on the road. So what I'm going to do is I'm going to head out. Thank you all very much for being here. Please remember, if you are or have previously been subscribed, just double check that Susan hasn't taken the subscription away from you. Not only have they done that with people that are members previously, but they do seem to like just taking subs away. And I am so damn close to 9,000. I mean, Jeff's keep going on about how he wants to get me to 10,000 before the end of the trial. But what do we need? 46 subs. And I'm at 9,000. Now, obviously, I'm not going to hold anyone hostage because I'm going to get the hell out of here. But as always, guys, stay healthy, wealthy, and wise. And remember, you are not a piece of shit. You do contribute to society, even if all it is by hitting that like button. Cheers, guys. Where are we? And play the outro, or at least the outro music.
Yeah, I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out.
Doesn't matter.
Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.